LIang Zhao. And is it Zhao or Zhao?
It's Zhao.
Zhao, okay. Thank you. All right. If you would like to retake your seat.
Thank you, Judge.
Well, actually, why don't we have
Sure.
you at the podium? We might as well. No, I can't yet. I need for you to take your seat first.
Thank you, Judge.
Ms. Sao Lee, I need to inquire of you now. If you could come to the podium so I could hear you. Thank you.
Your Honor, you can address me as Tasha.
Okay. All right. I will do that then. Thank you. All right. I would like for you to state your name first.
Xiao Li, Seowleelee, Tasha.
Okay. And Tasha, can you give the court your prior experience or your training and education in court interpreting?
I was provisionally qualified by the Supreme Court of Ohio, and my bench card number is 1619109.
Okay. And that involves specific training or recognizing training that you had already?
We have to go through a couple tests, the oral tests and the written tests, in order to get what I am right now.
Okay. Have you interpreted at other hearings before today?
Yes, Your Honor.
And what types of hearings have you interpreted in?
Almost every kind, federal to common pleas court, to traffic violation, almost every kind.
Okay. Are you able to interpret as the speaker is speaking? I have witnessed you doing this as I have been speaking thus far, but I just want to make the record. You are able to do it as it is happening.
Simultaneously, you mean, Your Honor? Yes.
Yes.
We're trained to interpret simultaneously unless it's and unless there is a witness stand on the stand, then I interpret for the witness consecutively.
Okay. Are you able to interpret literally without summarizing anything that is said?
I'm not trained to, it's not allowed to interpret in summary. It's on a verbatim basis, word by word.
Okay. Do you have knowledge of legal terminology in both languages?
Yes, I have learned of legal terminology, both with the Supreme Court of Ohio and with the Cuyahoga County, just learning the legal terminology.
Okay. Do you have a financial or other interest in the outcome of this case?
No.
Have you had the opportunity to speak with Ms. Chen, who is the client here for purposes of your being here? Have you had an opportunity to speak with her to determine if, in fact, there is any communication problem?
Yes, Your Honor.
Okay.
A couple times.
Okay. Do you feel that you are able to effectively communicate with her?
Yes, Your Honor.
Okay. Do you understand that while serving in an official capacity of interpreter for the court, you are bound by the attorney-client privilege and any confidential information provided to you by the client, Ms. Chen, other than what is being said for purposes of being said in open court, that you might be required to keep that confidential?
Yes, Your Honor. Confidentiality is one of the code of ethics that I have to abide by as an interpreter.
Okay. And do you understand that you cannot give any legal advice or interject your own personal opinions not related to language expertise?
Yes, Your Honor. That's part of my code of ethics, too.
Okay. Thank you. I would ask, I guess specifically, Mr. Drucker, are you satisfied with the qualifications of the interpreter?
Your Honor, I believe this interpreter is well qualified. However, I would like to reserve making a decision in that regard later should things break down.
Okay. and I can respect that, and I will give you that opportunity. Obviously, if anything changes, if at any time there is a lapse in the effective communication that is observed by anyone, they can bring that to the court's attention, and I can revisit that issue. All right, if you could have Ms. Chen come up to the podium with you. Ms. Chen, are you able to understand the interpretation provided to you by the interpreter? Yeah.
You have to tell.
Actually, it might be easier if you two would switch positions,
Yeah.
Mr. Drucker,
Sure.
so that the
Yep.
microphone is closer to the interpreter and to Ms. Chen.
Yes.
Okay. Do you feel that you are able to effectively communicate with your attorney through the interpreter?
Yes.
All right. Based upon the court's voir dire, or the court's inquiry, and the answers provided by all those involved, I will find that Ms. Sao Li, or Tasha, is qualified by special knowledge, skill, experience, training, or education to serve as an expert interpreter, and that the defendant, Ms. Chen, is able to understand and communicate through the interpretation provided by Tasha. Therefore, I will appoint Tasha as the interpreter in this case, and I now need to administer an oath to you, Tasha. Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially, using your best skill and judgment in accordance with the standards prescribed by law, and follow all official guidelines established by this court for legal interpreting or translating, and discharge all of the solemn duties and obligations of legal interpretation and translation? If so, answer I do.
I do.
Okay, thank you. All right, I am going to ask, as I've already done, but I will repeat, that we obviously all need to speak loudly, clearly, and slowly so that the interpretation can take place. And most importantly, that we only speak one person at a time. And I will say to you, Ms. Chen, that if at any time you are having difficulty understanding Tasha, to raise your hand and let the court know, and we can try to remedy the situation. Will you do that?
Yes.
Okay, thank you. All right. While you are at the podium then, I intend to proceed to the arraignment, which is in fact the purpose of today's hearing. Mr. Drucker, has your client received a copy of the indictment? Do you know?
Yes, Your Honor. My client received a copy of the indictment. She received it last week. It was served on her in the Stark County Jail.
Okay. Are you waiving any defect in time, manner of service at this time?
We are waiving any defect, Your Honor, yes.
Okay. Do you know if your client has had an opportunity to read it or have it read to her?
I can explain, Your Honor. She received the indictment, she's read it, she understands it. I went through with her all her constitutional rights. She understands the nature of the charges, the penalties that are associated with each one of the charges, and we're prepared to enter a plea today.
Okay. Are you, do you know if she would like to waive the reading of it at
We
this
would
time?
waive the reading of the indictment in open court, Your Honor.
Okay. I am also required for purposes of arraignment to inquire whether or not Ms. Chen is a U.S. citizen.
I can inform the court that she is not a U.S. citizen, and not a lawful permanent resident either.
Okay.
Your Honor, the interpreter would like to request a repetition from the counsel for the last sentence.
Okay. Go ahead.
Thank you, Your Honor.
Okay. Ms. Chen, I am required to advise you that conviction of these offenses contained within this indictment may have the consequence of deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States. You have been charged in the indictment with 6 counts, those being count 1, murder, a violation or a special felony. Count 2 is endangering children, which is a felony of the 2nd degree. Count 3 is also endangering children, a felony of the 2nd degree. Count 4 is tampering with evidence, a felony of the 3rd degree.
Your Honor, sorry, the
That's okay.
interpreter would like to repeat the last,
Go.
the 4th count.
Okay. The 4th count is tampering with evidence. Okay, and that is a felony of the 3rd degree. Count 5 is obstructing justice, also a felony of the 3rd degree. And count 6 is gross abuse of a corpse, which is a felony of the 5th degree.
Your Honor, excuse me.
That's okay.
The 6th, I'd like to repeat the 6th count.
Okay, the
and
6th count, gross abuse of a corpse, felony of the 5th degree. Okay. As to these 6 counts, Mr. Drucker, you indicated your client is prepared to enter a plea at this time.
That's correct, Your Honor. We're going to enter pleas of not guilty all the charges.
All right. I would indicate then that you will have a pretrial to be set, determining that the date of which will be determined upon whether or not we engage in further action today with regard to the issue of speedy trial, and as far as the trial date needing to be set. So I know, Mr. Drucker, you would like to have an opportunity to consult with your client about that issue. I would indicate that the court would be continuing the bond that has previously been set, and I would give you the opportunity now to have that time to consult with your client while we are addressing the arraignment of the co-defendant.
Thank you, Your Honor.
Okay? you all can have a seat when you're done. Okay, so Mr. Zhao, we can return to the podium now with your attorneys. All right. Have you received a copy of the indictment, Mr. Zhao?
Yes, Your Honor.
Okay. And I guess, Mr. Gorman, I'll just turn it over to you as far as any waivers that you wish to place on the record.
Thank you, Your Honor. Judge, I can tell you that I met with my client. He has received a copy of the indictment. He has read it. He understands it. At this time, we would waive the reading of it in open court. We would waive any defects in the time or manner of service of the indictment. We are prepared, Your Honor, as to the 6 counts that you previously described for the co-defendant. My client's named in all of those counts as well. We are prepared to enter not guilty pleas to all of those counts. I would ask the court to inquire further if you need to.
Okay. All right. Mr. Zhao, you understand that you have been charged in this indictment with the same 6 counts, those being murder, 2 counts of endangering children, tampering with evidence, obstructing justice, and gross abuse of a corpse. You understand that those are the charges against you as well?
Yes, Your Honor.
Okay. And is it your client's intention to enter pleas of not guilty at this time?
It is, Your Honor. I should also, I think I neglected to tell you that I did speak with him about the possible penalties contained in the indictment. He's aware of those as well.
Okay. All right. And we've already established that you are a U.S. citizen, so I do not need to advise you likewise as far as I did with the co-defendant. I will enter the not guilty plea, and again, I will be setting this for a pretrial dependent upon the issue of speedy trial. Have you had an opportunity to consult with your client, Mr. Gorman, about that?
I have, and anticipating that issue, Judge, I have had an opportunity to speak to him. We have before us, Your Honor, a time waiver on speedy trial. I can tell the court that I've discussed with my client his right to have this matter tried within 90 days of his arrest. Obviously, that would be 270 if he was out on bond, Judge, and I explained that to him. He's aware, Judge, that from a tactical standpoint, that would not be wise. That the defense needs to obviously receive all the evidence, receive all the discovery, and game plan a proper defense for him.
Okay. Have you had an opportunity to review the document then, and has it been executed?
The document, Judge, speaks to the waiver of speedy trial. I did not actually have my client read it, but if he took just 30 seconds, he could read it. We're prepared to sign it.
Take the time that you need to do that.
Okay.
That's the speedy trial statute. That's all it says. Okay. Judge, he's read the document. He understands it. He's prepared to sign the document. And I have already signed the document.
Okay. If you could...
Can I have him sign it?
You can sign it and have him sign it, and if you just want to walk it up to here or give it to the bailiff to give to me.
Thank you.
Thank you.
Thank you.
Mr. Zhao, do you understand that every citizen who is charged with a crime does have a right to have their case brought to trial within a specified period of time? In your case, because you are in custody, that period of time is 90 days from the date of your arrest. We do refer to this as your right to a speedy trial. What has been represented or what has been discussed here is your willingness or agreement to allow the court to schedule your trial date at a date beyond that 90 days. Is that your understanding of what is taking place by virtue of this document that you signed?
Yes, Your Honor.
Okay, you do understand your right to have the trial brought within that time period, though?
Yes, Your Honor.
And it is your decision today to waive that right?
Yes, Your Honor.
Okay. I would note for the record that you did have the opportunity to discuss this with your attorney. I've been watching you do it. Last question for you then is, do you have any questions remaining about this document that you just signed?
No, Your Honor.
Okay. Based upon all of that, I will find at this time that you have knowingly, voluntarily, and intelligently waived your right to speedy trial. I am executing the document as well, and I'm providing it to my bailiff to have it filed. I am obviously approving that waiver, and based upon that, then I will go ahead and schedule your pretrial for April 19th, 2017 to, did I say the 19th? I'm sorry, the 20th. Sorry about that. At 1 p.m.
Defense is available, Judge.
Okay, and I think we previously had gathered that. That will give your attorney sufficient time to gather at least the beginnings of, if not the bulk of the information that your attorneys will need to process and evaluate for purposes of preparing for any potential trial. We have not set a date, but we will do that on that date when we all get together next. Is there anything further?
Yes, Your Honor.
Yeah.
Judge, I'd like to reserve the right, and we would do it through a motion if we thought it was necessary or fit. We would like to reserve the right to address bond at a later date.
Okay.
And lastly, Judge, I would ask the court to allow us leave to file necessary pretrial motions that might go beyond the 35-day rule until we have seen all the discovery, had a chance to digest it, and figure out what we need to do.
I will grant you the reservation of that right. You can have that time to do that, and I will consider any motion, that is brought before the court. And I will also give you the opportunity to, you can always address that issue at any time as far as the issue of bond. But for purposes of today, it's going to remain what it has been previously set at. Is there anything further on behalf of the state with regard to Mr. Zhao?
No, Your Honor. Thank you.
Okay.
Thank you, Judge.
That'll be all for purposes of today for Mr. Zhao.
Thank you, Judge.
Thank you. Yeah, unless you need
Nope.
him for something. Okay, thank you.
We're almost ready, Your Honor.
That's, you take your time. You
Thank
take
you.
whatever time is necessary.
Thank you for your patience, I appreciate
No
it.
problem. Mr. Barr,
Yes, Your Honor.
the other case is off the record. The other case, what time?
3:30.
That's what I thought. Do you need to go back? before
No, I
you-
brought everything I need with me.
Let's go forward. Yes. We're ready, Your Honor.
Okay. If you would like to return to the podium. Okay. Ms. Chen, do you understand that everyone who is charged with a crime has a right to have their case brought to trial within a specified period of time? In your case, because you are in custody, that period of time is 90 days from the date of your arrest. We refer to this as your right to speedy trial. What is being discussed here today is that you may agree to waive that right or that requirement under the rules and agree to give the court, the state, as well as your own attorney, additional time in which to prepare for your trial or your defense in that trial. Is that, first of all, do you understand your right to speedy trial?
Understand.
Okay. And is that your understanding of what is taking place here now, that you are agreeing to allow your trial date to be set beyond that 90 days?
Understand.
There is a document that you have been provided. Has she signed that document?
She signed the document, if I can
Okay.
approach
You
her.
may. Okay. All right. Did you sign this document?
Correct.
Okay. And you did have an opportunity to discuss this with your attorney just now?
Yes.
Okay. Do you have any questions remaining about this document or about what is taking place today?
No.
Okay. All right. I will approve the waiver that has been executed, and I am executing it as well. I am providing it to the bailiff to be filed. I am finding that you have knowingly, voluntarily, and intelligently waived your right to speedy trial in this matter, I have now then scheduled an additional pretrial in your case for April 20th, 2017 at 1 p.m. Is there anything further that you wish to discuss today, Mr. Drucker?
No, Your Honor. Thank you.
Okay. That'll be all for purposes of today.
Thank you.
Thank you.
Nice day, Your Honor.
You all too.
Love the week.